Chair, an honor to be here at your committee, and my uncle, who's in your riding, says you're a nice guy. And if my uncle says you're a nice guy, I'm going to say nice things about you. So.
Thank you so much. And thank you to your uncle.
Certainly an honor to have you with us, Madame Raybould-Wilson, and your incredible work as a Justice Minister. And I want to talk mostly today on the issue of the gender lens and how it applies in the Indigenous communities. You have experience in many portfolios, particularly where we're talking with Me Too. It seems to me that this issue of the obligation of the state to prove the alleged criminal conduct of the defendant is a fundamental principle. But when it comes to sexual assault, it always ends up being that the woman seems to have to prove the case herself. And we have situations and issues of sexual assault, the practice of whacking the complainant, as they call it, where it's the credibility of the victim who's put on trial. And we see in the, the example of the Ghomeshi trial, that the question of the violence that he committed was never, ever the issue. The issue was the credibility of the women who were brought forward after the police asked for witnesses to come forward. I don't know if the provisions that you're bringing forward on consent are enough to protect women, to encourage them to come forward, and also to make sure that we maintain a balance of justice in terms of the rights of the defendant. So how are we going to square that circle?
Well, thank you for the question, and I'll say from the outset, it is an incredibly important question, and the objective that you articulated in your question in ensuring that we do everything we can to prevent or to protect victims of sexual assault, to ensure that we provide and create the space as best we can for them to come forward, is an objective that I think everybody around this table shares. We have sought to ensure in Bill C-51 that we clarify the law around consent in the criminal code, that we ensure that where that we expand the rape shield provisions, recognizing the twin myths and the ability of an accused to or the ability to introduce evidence that's held in the hands of the accused. Personal records of the complainant certainly can't be introduced for purposes of the proclivity of the complainant in terms of the activity, or that she's less worthy of belief, but that we set in place a procedure to provide a discussion or a voir dire of whether or not those personal records or private records of the complainant should be introduced in terms of procedure. And also the legislation, or the proposed legislation, provides legal representation to the complainant in these procedures. But beyond what's reflected in Bill C-51, we have a lot of work to do. I'm happy that the government has sought to start doing substantive work in that area.
Well, thank you. I'm pleased you talked about the need to move with effective resources, particularly for those who have a difficulty accessing the system. And I mean, the situation in Indigenous communities of the lack of resources, where we have spent months and months and months, police in our region, trying to get rape shield kits that were not available. So how do you get evidence if you don't have rape shield kits? So none of those cases could go to court. These are the basic resources that the communities that I represent don't have. And I'd like to ask you, the government is only paying for one shelter a year for Indigenous women suffering violence, and nothing up in Nunavut. Given the extent and the isolation in communities, if we don't have the resources for them to get out of violent situations, how do we expect that we're going to end the cycle of violence?
Well, again, I think ending the cycle of violence is an objective that we all share. And I hear you and recognize the lifelong advocacy that you have been involved in your remote community and the remote communities that you represent. We have done a number of things. Can we do more? Of course. And are we committed to ensuring we do everything we can to provide those complainants that actually do come forward, because not many of them do in Indigenous communities, as you probably know, that the tools and the mechanisms in order to be able to prove the charge are available, whether that be the rape kits, as you mentioned. We have made contributions in the area of $12 million in terms of our victims fund that provides supports to assist victims of sexual assault. We have a pilot project that's ongoing in Newfoundland.
I guess my concern is when we get to the fundamentals, for example, the child welfare system, the broken foster care system, it is the conduit for girls ending up on the street and boys ending up in gangs. And Tina Fontaine, you named the children who've gone through that system and have been victims of violence. And yet you're in court fighting the Human Rights Tribunal. So your government's put about $1 million fighting in order to end that chronic underfunding. And that underfunding is leading to young women and young boys being put out on the street and ending up in situations of violence. I don't get that. It's why are you not complying so that we can end this chronic denial of basic rights?